law matters. Welcome. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with law, because the law matters. A better understanding of the law makes you in a better position and better prepared to protect yourself, your family, and your business. As we present various topics, you may decide to handle some issues yourself. Our goal, as always, is to help you be prepared, to help you save time and money, and always to receive the best possible results. And once again, we want to welcome and thank Attorney David Bizarre from the Bizarre & Associates law firm in East Providence as he continues to weigh in on the topics that we discuss with his legal advice and wonderful anecdotes. So today, family court issues. What to consider when you're considering divorce. Alimony or spousal support, the amount, the duration, the terms, child custody. There are various types and kinds, legal, sole, joint, whatever, visitation. There are ground rules, there's a process, and they sometimes get very complicated. What happens? What factors impact on the decisions that will affect your life far beyond that final divorce decree? We know that there are monetary and social issues. There are behavior factors that come into play. How does that all work? And even your current job situation, how might that impact on both what you pay and whether or not you even have custody of your children? There's so much to discuss here. I hope we'll be able to get through both topics today, but let's begin, and let's start with the alimony situation. So you know you're going to get divorced. You want it. What do you do to prepare for it? What's going to weigh in on it?
So the first part of your question, if it was relating to alimony, is there's nothing you can really do because alimony is what it is, and there's certain situations you have to look at depending on where you live and what state you're getting divorced in, because family court is really a state-by-state issue, not a federal issue. So if you want to start with alimony, you're getting divorced, tell me where you live. Rhode Island or Massachusetts?
Let's start with Rhode Island first.
Okay. So Rhode Island has taken the position that alimony is, generally speaking, rehabilitative in nature. And what that means is that if you've been married for a period of time and one or the other spouse, because it's not the wife gets it or the husband gets it, maybe back in when I first began practicing law, typically it was the wife who would be looking at getting alimony, but it's not. It's based on what the facts of the case are. So if one of the spouses stayed home to take care of children and was out of the workforce for a period of time taking care of the children and is now just getting back into the workforce, but their earning capacity has been lowered based on the time out of the workforce, the courts look at that and say, well, we need to pay that spouse who was out of the workforce for a period of time some alimony in order to get them back on their feet and get their earning capacity back to where it needs to be. That's considered rehabilitative alimony. Generally speaking, the courts look at it as a 3 to 5 year period of time, depending on the circumstances. It could be much less. It could be 1 year. There could be no alimony, depending on the circumstances.
Is there a standard? I had read somewhere that if you were married 3 to 5 years, you might get 1 year of support. Is there some standard, or is it just on a case-by-case basis when they look at through the lens what the exact story is in each individual situation?
Rhode Island is case by case. Massachusetts is not. There's a statutory formula that will tell you how much alimony you're going to pay and for how long. And it is based on the length of the marriage, and it's based on a number of other factors, including income. But to go back to Rhode Island, because it's much more complex than just what we talked about so far, is there are factors that the statute says to look at, which do include length of the marriage and those types of things that go into it. But what the court will also look at, and when we sort of switched over to this idea of equitable distribution, so you would divide up the assets first, then determine based on the division of the assets and the earning capacity of each person what they need for alimony, if anything, and is it rehabilitative in nature. I had a case early on when we were talking about the beginning of rehabilitative alimony as a concept, and my client was a long-haul truck driver making a fairly substantial amount of money at the time, and his wife had a heart condition that prohibited her or precluded her from being able to really engage in any gainful employment. And so he came to me, and we were talking about a division of the assets and so forth, and I had made a recommendation of dividing the assets so that she may have gotten a little bit more of the assets so that he might not have to pay her long-term alimony. And he said, well, I talked to another lawyer, and he told me there is no long-term alimony in Rhode Island. And I said, no, the courts have said that we are going to look at it on a case-by-case basis, and predominantly it would be rehabilitative alimony. But in your situation, your spouse is not going to be rehabilitated to the point where she can really earn enough income to support herself. And you've been married for a long time. So I think you're looking at, in this case, permanent alimony. He didn't believe me. He went to another lawyer. The lawyer tried the case. The judge ordered not only the equitable distribution, where it favored the wife a little bit more that I suggested was going to happen, but also permanent alimony. So they appealed. And the Supreme Court said, no, we never said that there is no longer permanent alimony. It's on a case-by-case basis. And this is not a case where rehabilitative alimony would provide enough support for the wife in the future. So they upheld the award of permanent alimony.
Good case. Good. Too bad you didn't have an
He
opportunity to
stayed,
save him,
yeah.
save him in the first place. So in this case where someone is not able to be rehabilitated because of her health, in other cases someone might be, do they go back then and revisit it in 3 years? Or does the person who needs to be rehabilitated go back to class or get a degree or perhaps get another job? Is the burden on that person who's receiving alimony currently to provide proof that the person is trying, whether it's the male or the female in the situation? Do they need to do that?
So again, we're in Rhode Island. Usually when you negotiate a settlement of a case, there's a finite period of time for which the alimony might be paid, if it's paid at all. So if there is an award of alimony or an agreement to pay alimony, that period of time, the person paying it wants to know that at the end of that period, it's done. So the burden would be on the person receiving the money to know that it's going to end and I need to get myself into a place where I'm able to support myself. And it may be for education. It may be getting back to earning what you're able to earn. So usually the agreement is such that you know how long you're going to pay for it and you know how long you're going to receive it for, so you have to plan your life accordingly, as they say.
So when two people are planning to get divorced, is it always automatic that some spousal support is on the table, or might someone just say, I don't really care about alimony, let's just get right to just and only the equitable division of our assets?
Yeah, and again, in Rhode Island, when we're doing a divorce, equitable distribution is done first, because once you've done that, that could impact what somebody needs if they need anything for alimony. So when you're negotiating the divorce, you may include a little extra money in equitable distribution to one spouse or the other so that you can agree that alimony will be waived and it's not necessary. But the answer to your question about how long it would be and where you negotiate that, that's all done at the time of the divorce if it can be agreed upon. If it can't be, then it's left to the judge, and the judge could award, this is sort of what you were alluding to, a period of time, alimony for a period of time, and it could be, or you can also negotiate this, it could be subject to review. When I'm doing these cases, if my client's paying the alimony and I can negotiate a finite period so it's not subject to review and you're not going back to court and you don't have to present to the judge, well, this is what I tried to do, sorry, I couldn't find myself any job sufficient enough to support myself, so it's going to continue on and continue on and continue on. For the most part, if you're representing the person paying it, you would prefer to even pay a little bit more as long as there's a finite period of time that you're going to pay and it's going to end.
And is there a situation, as I started to read about this a little bit, I hadn't realized this, when someone separates and a divorce is in process, where temporary spousal support. I guess they don't call it alimony. It wasn't, the divorce hadn't happened, but temporary spousal support during that duration when you're going through, whether it's a short term or a long, protracted, contentious issue. How do you go about getting that piece that takes care of the spouse during what could be a short or a long time?
Yeah, so I've seen it called alimony pending litigation.
Okay.
I've seen it just called spousal support or temporary spousal support. On a temporary order, the parties have separated, there's bills to be paid, and that has always been an issue in cases, especially when I first started, when a divorce could take years. It might
Yes.
not be done in the 12 months that a contested divorce might take today. So that amount of money that was being paid temporarily, that temporary period for a lot of people seemed like forever. And then what would you do? Would you say to the judge, now we're talking about rehabilitative alimony, well, I've just paid 3 years of alimony, so to speak, because I've been paying this support during the litigation? Yeah, that is a very interesting situation from a tactical standpoint as a lawyer, that you want to try to figure out what's fair for the parties, but also we don't want to create a situation where someone's receiving more money than they might get at the divorce period of time, so that it's being dragged out or stretched out intentionally.
And what about Uncle Sam? So when there is a divorce and there's alimony, some part of that's tax.
It used to be.
It used to be, okay.
There was a time frame, and there was a period of time when there was someone who was a large wage earner who was going
Yes.
to pay child support
Yes.
and alimony, and perhaps we would try to structure it in such a way that it was more alimony than child support, so that it could be deducted from the person paying it, and the tax would be passed along to the person receiving it theoretically in a lower tax bracket. There were some changes to the alimony rules, so you have to look at that pretty closely, because that's not the case necessarily.
Okay, and so if someone's had this lengthy spousal support and it finally gets to judgment day, so to speak, could the person who's paying spousal support say, well, I want to subtract that from my side of the ledger of what I owe because I've been carrying this that far anyway? And you said you want it to be finite. Do you get to go back and say, I've paid a sum total of this, can we take that off the top?
Well, I would certainly argue that is, if it's a contested divorce and it's going through to a judge for a decision, I'd ask the judge to bear in mind that this is what's already happened.
Yes.
And again, it's much quicker now to get from the start to the end than it was many years ago. But even so, if you've been paying for a year or 18 months or 2 years, I don't know if you want to necessarily call it credit, but some consideration
Okay,
has
fair
to be
enough.
given to that.
So I understand that all but the very wealthy can reasonably assume that when you have a certain pot and now it's divided by two, both are likely to have somewhat less to work with. Yet I also understand that the judge, the court, will consider maintaining to some reasonable extent what the other person's or each person's state of living, or what their usual maintenance, or what their usual lifestyle is. Both are presumably going to drop. How do they figure out that you, because you made more money, should be able to maintain a higher standard of living than the one who you are somewhat subsidizing? How does that work?
Yeah, it's difficult because, as you said, you had one household, an income to support one household, and the assets that
Yes,
are in one
yes.
household. So now you're getting divorced, and theoretically, if it's been a long-term marriage, or for the most part, a situation where the assets are going to be divided 50-50, and equitable distribution doesn't necessarily mean 50-50, but just assuming that's the case in our hypothetical, we divide the assets by half, now we have the income. And you don't necessarily divide the income in half, that's not how it works, but the issue you raised about a standard of living and a lifestyle, there's some consideration in, even though it may not be top of mind or what it's going to be, you do want to look at sort of what's fair and equitable. But it's hard because you're now dividing up assets and income from one
Yes.
household to two.
Yes. So if you will tackle in Rhode Island, we may have no fault, which means if you want that divorce, you can get that divorce. However, the issue of fault, meaning behavior, someone cheated, someone was addicted to drugs, alcoholic, whatever. How does that impact on some court's decision about who gets what amount of money? Never mind it's going to impact on custody. We haven't even broached that subject yet, but how do they factor that in?
So it can factor into two issues, starting with equitable distribution. The conduct of the parties
Yes.
is one of the factors that's looked at in how to divide assets. Now, I'll say this, conduct of the parties can be both good and bad. So good conduct, how were the assets acquired? What did each party do to contribute to the acquisition and maintenance of the property that was acquired during the marriage? And bad conduct. What did the party do? Did the party waste money? Did the party gamble? Did the party drink? Did the party cheat, as you said? All of those are issues that the judge can weigh in deciding, among all the other factors of equitable distribution, how it should affect the division of the assets. So bad behavior can have an impact on it. I don't think, for the most part, it's been 100-0, 50, from 50-50 to 100-0 kind of thing, but there can be some percentage increase or decrease depending on the action or conduct of the parties.
And again, that doesn't mean that you are denied getting a divorce. No fault means you can still get the divorce, but it can impact on how you distribute.
So the grounds for divorce can be a no-fault ground, which could be irreconcilable differences, which of course the irremediable breakdown of the marriage, or in Massachusetts, the marriage is irretrievably broken. The grounds for the divorce at one time were a very important factor because historically you had to prove bad conduct, certain things that happened. People who were habitually drunk, gross misbehavior repugnant to the marriage covenant, adultery. All of those things not only had to be proven by you, but there had to be witnesses that could prove it.
Really?
And it's because we didn't want people to get divorced. Rhode Island, traditionally a fairly Catholic state, had those reasons, prohibitions almost, about getting divorced. And so we wanted to make it difficult to get divorced. And so in the 70s, around that time, we sort of became a different standard. And as it advanced, we developed what we just called the no-fault divorce, which was, I don't have to prove that there's any fault on anybody's part or on the person I'm suing for the divorce, but rather that for whatever reason, this marriage just doesn't work anymore.
Good. So you've spoken, as I asked, you've addressed the issue about a Rhode Island resident or two Rhode Island residents. How does that contrast or compare with what happens with Mass residents?
Well, in Massachusetts, as we were saying, there is a statute on alimony. And if you are married for a certain amount of time and there's other factors that go into it, they almost have, well, they don't, not almost, they have a formula that you look at and say, this is what you're going to pay for alimony, much like the child support statute, which says this is what you're going to pay for child support. And if you get beyond 20 years of marriage, it's potential that you're going to pay alimony for life, or for what would seem to be life to the guy who's paying it or the girl who's paying the alimony. But yeah, so it's a formula as opposed to the judge having discretion to look at each case on a case-by-case basis.
And if you happen to, and we haven't talked about custody yet, but if you happen to be the custodial parent, how does that factor in when it comes time to look at alimony? Alimony is supposed to be support for the spouse. Presumably, that might impact on, I don't know, the custodial parent's ability to work overtime, 40 hours more. I mean, it might have some impact. How do you address that?
Technically, there's sort of two separate issues.
Yes.
Because you have custody, you're going to have child support payments, and the child support payment, as the judge is looking at what you're going to pay in Rhode Island, will actually impact what alimony may or may not be, because the person paying it, the ability to pay is also an issue. And the ability to pay alimony on top of child support may not be that great, potentially. So that's one of the things, it's not technically, one to look at the other, that they're connected, but it could have some impact.
And what happens if the decree is made and the amounts are settled and someone doesn't pay? How does that get enforced? And does it get enforced well, and
Yeah.
how does that work?
So there's two different ways, and it depends on how it's ordered. So if you're ordered to pay, are we talking alimony or child support or both?
Let's alimony first. Let's stay
Alimony.
with that for the
You're
moment.
ordered to pay alimony. If it's by a judge's order and you don't pay it, you're in contempt of the order, so you can be brought back to court in front of the judge, and the judge can not only order you to pay, but if you don't pay, send you to jail as one of the contempt remedies.
Truly.
In order to force your payment. Same thing with child support. If it's a contract, a property settlement agreement, a marital settlement agreement where you've agreed by contract to pay it, well, the first thing you're going to do is be sued for breach of the contract, and the family court judge then will order you to pay it. And if you don't follow the judge's order to pay whatever that judgment is that you owed, because each day or each month, whatever it is, for child support or alimony could be considered a separate judgment. So you could then be ordered to pay the judgment, and now if you don't pay that, the judge can order you to go to jail for not following that order.
And does it have compound penalty and interest as well?
Well, child support certainly can have interest. In your contract for alimony, you could lay out what the penalty would be, which would usually be having to pay the other side's attorney's fee for having to
Okay.
bring you back to court to enforce the contract. There could be other penalties for late payments if you've negotiated those in. And a judgment in Rhode Island carries 12% interest.
Wow, that's substantial. So how about when it stops? So if you are paying spousal support alimony, if you die, you're not paying, but you might have an estate. Does that have to continue to pay?
So that's a good question, and it depends on what the order or agreement is. If you've agreed to pay for alimony for a certain period of time, and it doesn't say, because you can put this language in, that alimony ends on the death of either, certainly on the death of the receiver.
Receiver, certainly.
But if it's not on the death of the payer, then it could be written into the contract that the estate is responsible for paying the balance of the alimony. And when it's an order from a judge, it could be, I've seen actually written in where there could be insurance, life insurance, that's been put in place to guarantee the payment of whatever's due.
Okay. And if the receiving spouse, ex-spouse, remarries, that would terminate it for certain, sure.
That's usually one of the triggers.
Or what if that receiving spouse begins to cohabit with another person?
Yeah, we've written that.
How does that work?
Yep. So it's been written in. I've had cases where we've written in marriage or cohabitation and then define what it means, because you don't want someone to try to skirt the actual body of what you've agreed to, the spirit of the agreement by, I'm not going to marry that person, I'm just going to live with that person, as if it's any different than what it really is. Especially if it's in the old marital home. I have clients who are paying alimony and have given the spouse the house, so to speak, and now she's living with someone else in my house and I'm paying. What are you talking about? I'm not doing that. So we've tried to written in things along those lines.
What would happen if you're not cohabiting with a person of the opposite sex, but the same sex, with or without it being in that kind of relationship? Maybe decided to choose a roommate just to share expenses. Does that impact adversely? Or
back in the day, we used to write it in, and it used to say member of the opposite sex.
Right, that changes now.
Yeah, it's different, and
Yes.
and I guess you have to look at what is it you're trying to protect. What is it you're concerned about? Are you concerned about just someone living there that's not in a romantic relationship?
Okay.
Or are you worried about the romantic relationship? What is it? So you have to be careful about how you spell that out and what it is you intend to protect against.
And then you'd have to try to have someone witness what that is and the terms of
The
that
evidence,
relations.
difficult, right?
Could be a sticky wicket, to say the least.
The proof of what it is. Is this a romantic relationship? How are you going to prove that? What is it? What is it that you have to bring to the court to show?
And if you moved parents in to help you take care of the child, if that's the situation, could they possibly undermine it? So you have to actually go through this and spell all of these things out in some degree of detail.
I would think so,
There are so
because
many
one of the things you could have moved in was a nanny or a caretaker. Has nothing to do with the other issue that you're concerned about. Should that affect it? No, it really shouldn't. But you want to make sure that you understand what it is that is of concern and that the language is written for both sides so that they understand what the ground rules are.
And does any of this change if you lived in Rhode Island versus Mass, for one thing?
Well, I think the contract, if you're doing it by contract, is going to have similar things written into it.
And what happens if one is in one state, one is in another? How do you determine whose ground
State?
rules?
Yeah. So are you talking about at the start of a divorce or after the divorce?
Let's start with the start.
Okay. It's an interesting question, and I have not always agreed with what some of the court's interpretations have been. But if one spouse is in Rhode Island, they were married in Rhode Island, they've lived in Rhode Island for most of the marriage, and then the other spouse moves to Massachusetts and stays there for the statutory period of time required to file a divorce, typically 1 year, and then files in Massachusetts, which law should apply? And I think it should be a conflict of laws analysis that says which state has the most interest. Massachusetts has traditionally said, well, Mass law applies, the spouse lives in Massachusetts. I kind of disagree with it being just based on where you live when you filed. I think it should be a more in-depth analysis of what it is, but there's a whole set of laws on conflict of law and which state law will apply. And it's a balancing, and it's really looking at what's the state's interest in it.
And one final question relative to alimony, which is if a couple is living in the same home and one decides, I'm not safe here, I don't want to be here, or whatever, whoever leaves the house, do they somehow sacrifice their legitimate claim to it at the time a judge has to look at the unfamily of family court?
Yeah, so when I look at it, and you're telling me that you're concerned about your safety, or whatever it might be, an abusive situation, I say get out, and that's not going to affect equitable distribution or your right to alimony or anything else. And if someone's moving out because they just can't take it anymore, and they're the ones who've been generally bringing most of the income, I say as long as you pay the bills and you continue to do what you need to do financially, I don't consider that abandonment. You're just trying to make yourself be in a better place.
And would that apply to Massachusetts and most other states
I
as
think
well?
you could argue that in almost any state, especially with the abuse situation where you're trying to protect yourself.
Do you find that people are conniving enough to try to plan their exit
Yes.
and do these things?
Yep.
And I know we have 2 seconds left, but is there anything that the other side can do to offset that?
Just make sure they've taken whatever steps to protect the assets that they can.
Okay. We had hoped to talk about custody. Perhaps we'll have to deal with that next time. We thank you for tuning into the Law Matters. Please continue to stay tuned. As we say, the law matters to you.